and I know it was one of the, let me pull up here and get the bill number. So in 2021, you testified on the guardian ad litem reform 1315. So one of my biggest issues with the current family court system is I say it's pay to play. At the end of the day, it's pay to play, whether it be you get slapped with unreasonable supervised visitation, you got to foot that bill, evaluations, therapists, court costs. Some judges are having you return every 3 or 4 weeks to court, and
time off work.
Yeah, time off of work, and then you're paying several $100s an hour for one of us to be there to represent you. So in terms of what's your opinion on, we'll go specifically with guardian ad litem. It's not super common in the areas I practice to have a guardian ad litem or a child's attorney. But what's your opinion on them, and what type of change do you think would make those individuals more effective?
So a guardian ad litem is supposed to be an independent lawyer that is appointed by the court to help advise the court as to what it ought to do in the best interest of the child, independent from the zealous representation that mom's lawyer and dad's lawyer give. So that's guardian ad litem. And they provide a very valuable role. They're needed, as attorneys, we take an oath to zealously represent our clients, not necessarily the child. And that's where the guardian ad litem comes in. Now with everything, there are, bad apples. And, I think the biggest focus,
we've seen that in Missouri.
Yeah. I think the biggest focus for change needs to be on accountability. I have had months go by trying to get in touch with the GAL. And, you can call, you can email, you can, if I have to, put a letter on my formal letterhead and send it out, things have gotten pretty bad. And, the reality is, the guardian ad litem sort of becomes someone that you've kind of also have to persuade or win over. And so it's difficult then to, I don't want to use the word challenge. It's too strong a word, but to seek some type of accountability that says, hey, I've been calling you for a couple of weeks and I haven't heard back. So I think the biggest change, or what we're wanting to see, is some sort of accountability mechanism for them, because they provide such a valuable role to the court.
Yeah. And so this is the thing. I think my piece, specifically how a lot of these third parties are used in the state of California, we operate under the presumption that a lot of times that dad has to prove he's a fit parent. And in reality, we need to take a look at it. And 99.999% of parents ultimately just want to spend time with their kids and want what's best for their kids. I think if we shifted our thinking to, okay, if there's an actual issue, if there's actual substance abuse, if there's actual domestic violence that we can ascertain from what's been provided, then these professionals may be necessary, they may be needed. But I think a lot of times we pull these professionals in and it just muddies the water. And in my opinion, I think a lot of judges, at least in Southern California, utilize these professionals so they aren't the ones making the ultimate decision. They utilize that opinion or that report, whatever they provide, to guide them in their decision making. So the ultimate decision is not on the judge.
We have our statutes here in Missouri are pretty strict in terms of, if there are allegations of abuse or neglect, a guardian ad litem shall be appointed. There's no discretion by the judge. They have to do it. Yeah. So I think the fix there again is legislative. And that's why we've, at AFESP, we work so hard creating these relationships, and TFRM does a great job on outreach, and NPO with their surveys and whatnot. But the fix, the solution to these problems is legislative. And so if it is, and I think it should be, if there's no one wants a kid going to where they're going to be abused. So if there's abuse or neglect alleged, then absolutely, a GAL ought to be appointed. But let's look at what it means to allege abuse and neglect. That's where the legislative fix comes in, because the statute in Missouri is so loose on what is required for an allegation of abuse or neglect. For example, it just says if abuse or neglect is alleged. It doesn't say by whom. I've had lawyers allege it, but they're not the parents. It doesn't say under oath, and it also doesn't say with any type of specificity. So, I had a case once where a lawyer came in and hand wrote, I think, a I'm not even going to say a 1-line motion, a 5-word motion for GAL, dad abused kid. And the judge's hands are tied. I mean, the statute says if it's alleged, you've got to appoint a GAL. So I think, in addition to the accountability we just spoke of, I think we need to look at the underlying statutes and laws and fix those. Because I think if we had some guideposts on abuse and neglect, then at least I can say to my client, well, look, it's not a 5-word motion. Here's what they're alleging with specificity, so that I can then, investigate it, challenge it, look into it. I'm just not dealing with some amorphous, well, there's abuse.
Yeah. And I think that's another very, very large challenge. Are these allegations where I think there are a lot of states that have statutes. California is one of them, where abuse or domestic violence is defined so broadly that it's next to impossible to defend against these things that could be completely baseless. They could be based on something. You can't really pinpoint what exactly they're trying to say, but all of a sudden there are all these levers that have to get pulled because there's a domestic violence allegation, there's a child abuse allegation, and the party that it's being alleged against, the allegations are so vague, you can't even defend them to the judge. As an attorney, even it feels like this. You're basically saying, "No, that didn't happen," and that's all you can do.
Yeah. I mean, now it's a little bit different with, again, we talked about the younger demographic. Along with that younger demographic comes technology. So everyone's walking around now with a video camera in their pocket. And so, if that's always running, you might be able to, negate some of those. I mean, the problem is, domestic violence, is real. It occurs. These abuse statutes, because of that, are necessary. The problem is, on the other hand, as a practical matter, the Adult Abuse Act is one of the most abused statutes in Missouri. So, there's not even a filing fee, for crying out loud. Even $20. And again, that's another legislative fix we're looking at. If there were some type of filing fee, right now, it acts as without a filing fee, and the clerks are required to help a litigant write out the petition for an order of protection. It becomes, I kind of call it jailhouse justice. I mean, I'll show you, I'll get back at you. And I see it on both sides. Both men and women, file these things. The problem is we just, I think, legislatively need to find the balance between, because I've also represented horrible cases of domestic violence where, mom just, had the pulp beat out of her. So we need the protection. It's real. It occurs. We also, though, need some, protections in terms of, a $20 filing fee waived if you accompany it with a police report, I think solves some of those problems.
Yeah, I think I won't even say one of the most abused in the state of California is Family Code Section 3044. And there are parties that instead of responding to a divorce or responding to a petition for parent, they filed they filed for a domestic violence restraining order.
Yeah.
And no joke, I had a temporary restraining order that got granted against my client after we had filed for custody.
Yeah. Her
allegation was that he drove by her house.
Mm-hmm.
They'd been co-parenting separate for 10 years.
Mm-hmm.
Her allegation was he drove by her house.
Mm-hmm.
And if we'd have been able to respond to that before they granted it, we had work records that showed that he wasn't even in the state when she made this allegation. But he all of a sudden loses almost a month worth of time of parenting his children. He couldn't go to his son's football games. So it's one of those things in California, the way the statute's written, it's used as a sword. It's not.
Yeah. So, and that's where a temporary order entered at the beginning of the case solves these problems because it reels in the emotion. The first thing I'll say to a client who's filed an order of protection is I'll say, well, the first thing we're going to do is we're going to dismiss that. And their jaw, kind of drops. And I said, well, in Missouri anyways, it's only good for a year. It can be extended for another year, up to 2 years. But if your kiddo is only 3 or 4, you don't need an order of protection. You need a parenting plan. You need a custody order. The problem is, orders of protection have no filing fee, and you have assistants filling it out. You don't have to hire a lawyer for it. That's why it's the go-to thing to do.
And in the state of California, it's preponderance of the evidence to get the administrative restraining order granted.
Right.
And in the state of California, that creates a presumption for 5 years that parent that it's granted against shouldn't have any legal or physical custody. So all of a sudden, I would say 70 to 80% of my clients have either prior to me representing them,
Yeah.
had a DVRO granted against them, or we've defended against a domestic violence restraining order. But it's such a sword that, I mean, like I said, the client who he had to, like, we had to go in and defend that he drove by.
Right.
It was a hearing that we were in front of the judge for 5 minutes, and the judge was like, no, this isn't anything. In my head, I'm like, why did you sign off on a temporary restraining order being granted? Because your name's the one that signed off on this.
Right.
But that data, all of a sudden, that was the preparation, and multiple witnesses showed up that day, everything else. I mean, everybody involved, like, lost work, attorney's fees, filings, everything. It was probably a $2,000 expense to their immediate circle to disprove this flimsy allegation that was just signed off on without looking at it.
Well, not just that. I mean, can you imagine? I know a lot of your viewers don't need to imagine. I'm sure they've experienced it. But coming home from work one day to a sheriff standing there saying, you've got 10 minutes to get your stuff. It's, well, where am I going to go? Sheriff's not my problem. And where are you going to go? A buddy's couch, your parents' home? But what about the job that you've got to have your work attire for, or whatever, or your tools? Mm-hmm. You know, you don't have time to get all the tools in your shop, in the garage or something, you know? But again, I think what we work towards with AFESP is a legislative fix to these. So I think some ideas like a filing fee, waive it if there's a police report, will help hopefully curb some of the abuse. It's a very tricky issue. And this is, and I've never had, obviously 3044 in California is something that needs to be changed because of how it's weaponized and how it creates this contention when it's really in most cases not actually necessary. It is necessary in some cases. Well, if you can get in early enough, and that's, you know, the best work I can do is when I can get into a case early enough. When someone comes to me saying, well, I want to file an order of protection. I say, wait a second, let me, what's going on? Well, he drove by my house. Well, that's not quite enough. What you really need is just, let's file your divorce or your custody and deal with it that way. So if you can get in early enough, because what that does is that controls the emotion, that controls that I want to get back at him or her. The way you get back is, you know, living your best life. You know? Yeah. And I think that goes part onto our profession. Yeah. I mean, there are several, like I know in the equal and shared parenting community, there are a lot of individuals who don't necessarily like lawyers. And I see that every week in the comments. But I would say the vast majority of lawyers, when the lawyers go to talk and it's just the two of them, are like, we really don't need these things. Our clients are kind of driving this. Like, is there middle ground that we can make a deal right now? Yeah. Because I'll tell you this, like the happiest that two lawyers, that at least personally in my experience, is like you show up to court on that first day and the two lawyers tell the parties go stand out at the other ends of the hallway. You meet in the middle. And before you even go in front of the judge, like you're like, hey, we got this figured out. Yeah. And it may be 2 months from filing to them having some sort of stability in terms of a custody. Well, that's just it, is how do I get stability back in my client's life as soon as possible? And that means a schedule, their kids, financial things straightened around. And that's why, again, these legislative fixes are so important, because they do that. Again, there's no point going back to court to get more time with your 5-year-old if by the time you get it, they're 8. Absent, there are complex cases, absolutely. But I mean, the majority of cases, it's not rocket science. There's no reason cases should take 18 months minimum. I've seen cases drag out 2-3 years. There's no reason. There's none.